My name is Brock Jolly, and I'm the treasurer of NAFA, and I'm excited to be here with you today. I'm pinch hitting for Keith Gillies, who had a conflict, but very, very excited to be here. This is a great collaboration, another great collaboration between the National Association for Insurance and Financial Advisors and the Society of Financial Services Professionals. I've been fortunate to be a member of both organizations for nearly 20 years now. And I really see both as a valuable part of my business and critical part of my growth as an advisor. The advocacy piece that NAFA provides are both really, really critical to my success, my growth, and what we try to do and how we add value for our clients and our practice. A couple of things just real quickly. Wanted to give a quick shout out to our sponsors. Our sponsors for today's event are Pac Life, Mutual of Omaha, and Beacon Financial. So really, really appreciate the support. These events don't happen without your support. And we are very, very appreciative of you being here and supporting this event. Also just really excited for the continued collaboration with the Society and NAFA. We want to bring more of these type of events to our members. And so thank you to all of you for being here today, because obviously with this number of folks jumping on, it is important. We see the value that it's providing. We want to hear from you. So if you've got feedback on the event or on future events, would love to hear from you what you'd like to see with events like this. Also want to draw your attention to NAFA's Performance Plus Purpose Conference coming up in just a couple short weeks, October 6th through 8th. You can register online. Registration is open. That event is noon to 3 p.m. each day. And if you just go look at the agenda, it is jam-packed. Lots of great speakers, great breakout sessions. I do want to draw your attention that Kathleen, one of today's speakers, will be a featured speaker. Very specifically, her session is on October the 8th at 1:45 p.m. Eastern. So if you like what Kathleen Bilderback says today, please make a point to join us on the 8th. I asked her for a little bit of a teaser. She said it's going to be an even better drill down of some of the stuff that we're talking about today. So if it's good information today, and we'll also have a case study. So I know that a lot of you who are joining us today, you love those case studies. So please make it a point to join us for the Performance Plus Purpose Conference, and very specifically Kathleen's session on the 8th at 1:45. So with that, I'm going to turn it over to Rob Wellendorf. Rob is the immediate past president of the Society of Financial Services Professionals. I've gotten to know Rob a little bit over the last couple of years. Just among other things, just a great guy, dynamic personality. I see why he's so successful, not just in business, but in life. Rob is the founder of Exexo, a really cool planning firm based in Omaha, Nebraska, that aligns family, wealth, legacy, and philanthropy. He's an accredited estate planner, as well as a chartered advisor in philanthropy. So with that, Rob, I'll turn it over to you to introduce Kathleen and get us kicked off for today. Thanks, Rob.
Wonderful. Brock, thank you, and a huge welcome to all the participants on behalf of the Society of Financial Services Professionals. We're so glad you're here. It, as Brock had indicated, has been a wonderful relationship between the Society and NAFA, and very similar, as I know many of our participants would be saying the same thing. I've been a member of both for over 25 years and enjoy the benefits and the relationships very deeply, which is obviously the way we vote with our membership dollar these days. So again, I'm glad you're with us today. Most of you, perhaps, this is session 2, you were with us last week, so I'm glad you continue this journey with us and with the Feldmans. I just want to mention a brief update from the Society of Financial Services Professionals. We launched late spring a storefront called fspgo.com, so Foxtrot Sierra Papa.com. And essentially what we've done is taken our 93-year history of providing advanced market training and materials, both written publications, webinars, and they're in different categories based on what you're looking for. So I would encourage you and the associates in your office to take the opportunity to check out fspgo.com. Let's jump into the Feldmans for the next perhaps 55 minutes. And regarding the fact pattern, we spent a little bit of time last week in detail looking at mom and dad, Jack and Diane, of course, and the 4 children, and then also 4 children being Abel, Patty, Sheldon, and Keegan, and then also pointing out the key employee, Maya. So Ron Lee last week spent his time and attention on Generation 1. Kathleen's really going to drill down on Generation 2. So you'll see in the fact pattern with Generation 2, we'll be talking about retirement planning, business succession from G1 to G2, a strategy to retain Maya, who's the key employee. Additionally, discussion on recruiting and retaining other key employees, and then also the estate planning aspects related to G2. A case of this complexity, a case of this detail certainly requires experts. And today I want to introduce Kathleen Bilderback. I'm going to use the abbreviated bio so we can get to her material. And as an aside, I've again had the opportunity to work with and be around Kathleen for, almost a decade now, and continue to learn and continue to be impressed. I'm so glad you are helping us understand the Feldmans. Kathleen graduated from St. Louis University with a degree in accounting and theater, received her law degree and the LLM in taxation from Wash U School of Law. She specializes in estate, business, and executive benefit planning, estate executive compensation planning, and is expert utilizing life insurance in these strategies. Formerly was a member of the Advanced Markets Group of MetLife, where she provided training and advanced underwriting support for the top producers at MetLife. Currently a member of the Missouri Bar, Illinois Bar, and Pennsylvania Bar. Formerly was teaching adjunct professor in the LLM program at Washington University School of Law. She founded Affinity Law Group, is a member of the Business Insurance and Estate Planning Committee of the Association of Advanced Life Underwriting, and currently is president-elect of the Society of Financial Service Professionals and has served on the board as a director for many years. So we need expert assistance with the Feldmans, Kathleen. Let me hand it to you.
Thanks, Rob. And thanks everybody for inviting me to be here today. We're going to move ahead and talk about Generation 2 of the Feldmans. Next slide. So specifically, we're going to talk about Feldman Family Generation 2, what their issues and needs are, and some possible solutions. But we're really going to spend the majority of our time today talking about Maya. Maya has a lot of issues. She has a lot of needs. We have a variety of different solutions that we can propose for Maya. And we're going to talk about other members of the executive team. What do they need? Why do they need it? And what can we provide? So if we move on, you may recall from last week, for continuing education purposes, we have a number of survey questions spread throughout the presentation. These questions are necessary for CE credit. Now, I'm an attorney, a practicing attorney. If you were here last week, you know Ron's questions tended to be opinion questions. My questions have answers. So watch out for those survey questions. Next slide. So who are we talking about in Generation 2? Well, we have Abel, who's the Senior Sales Director, Patty, who's the COO, Sheldon, who has the title of Innovation Strategist, and Keegan, whose occupation seems to be Playboy. Each of these children own 5% of the company that was gifted to them by their parents. Next slide. We have a number of issues with the Generation 2. First, estate planning. Do each of them have estate plans in place that's going to take care of their assets in the event of their death or disability? retirement planning. Abel, Patty, and Sheldon have concerns about funding their retirement plans. And business succession planning. What happens to their equity if they die or become disabled? Next slide. Here we go with some succession planning. So when we work with families in succession planning, we have to answer a number of questions. First, if somebody passes away or leaves the company, who's going to reacquire their equity? Will it be a redemption by the company? Will it be all the other shareholders who have the opportunity to acquire the departing shareholders' interest pro rata? Or should it be only the employee shareholders who are actually active in the business? We also have to address when these shareholders or the company are going to buy the stock. Is it going to be at death, at disability? What if one of the stockholders retires or voluntarily leaves the company to take another position elsewhere? Or if there's a proceeding against the shareholder, meaning if the shareholder is going to get divorced and the shares are at risk of transfer to the other spouse, or if the shareholder has an assignment for the benefit of creditors or a bankruptcy, should the company and the other shareholders have the opportunity or the obligation to reacquire the departing shareholder's interest? Next slide. A lot of our conversations revolve around price. Now, when we're dealing with unrelated third parties, we learn in law school the concept of willing buyer, willing seller. That is, fair market value is the price at which equity will pass between a willing buyer and a willing seller, neither being under any compulsion to buy or to sell, and each with knowledge of all the relevant facts. When we deal with family situations, we have some additional requirements. Section 2703 of the Internal Revenue Code says that in order to fix the value of the stock for estate tax purposes, we have to meet some special requirements. First, it has to be a bona fide business arrangement. A buy-sell agreement is a bona fide business arrangement. We have all the time drafting buy-sells between unrelated third parties. It can't be a device to transfer property to family for less than full and adequate consideration. So in other words, you can't pay such a low price under the buy-sell agreement that there's actually some type of gift to the other shareholder. The terms have to be comparable to arm's length agreements between unrelated third parties. And there is a question about discounted valuation. So typically, let's think about Feldman Generation 2. Each of them owns a 5% interest in a closely held business. Those types of interests frequently qualify for discounts, such as discount for minority interest, discount for lack of marketability. Even in some cases, the IRS has said that there's a discount if the property owned by the entity has substantial capital gains. So what does 2703 say about discounts? Well, discounts exist between unrelated third parties. However, sometimes we don't want them to. So in the buy-sell agreement, we really need to address whether price, fair market value, is going to be at controlling interest value or at discounted value. If it's at controlling interest value, each of the Generation 2 Feldman children would be entitled to 5% of the total value of the entity. If it's a discounted value, then that 5% would be subject to those lack of marketability and minority interest discounts. Next slide. This is always a big question too, particularly in multi-generational family businesses. How will the children pay if they buy the equity from their parents? Will it be an installment sale? Will they purchase life insurance on their parents in order to buy the stock at death? If they buy insurance, are they going to fund it through an executive bonus arrangement under Section 162 of the code? Are they going to set up a split dollar arrangement? We're going to get to split dollar arrangements in a few minutes and talk about them in more detail. Are they going to set up a separate entity, an insurance LLC, to hold the life insurance contracts to fund a cross-purchase buy-sell arrangement? If they set up a separate insurance LLC, and this is a mistake that many attorneys commonly make, you need special provisions in the operating agreement for that LLC to have it perform correctly. Next slide. So my first polling question, remember, there are right answers. IRC section 2703 requires that a buy-sell agreement between family members be A, a bona fide business arrangement, B, not a device to transfer property to family for less than full and adequate consideration, C, comparable to arm's length transactions, D, all of the above, E, none of the above. So I believe that all you have to do is click the right answer. I see the poll still in progress. Wow. Don't be shy. Okay. 95% of the participants said all of the above. Congratulations. Okay, moving on. Now we're going to talk a little bit about Maya. As you know, if you reviewed the facts of the case study, Maya is currently the Vice President of Strategic Operations for Synergy. She's the company's most valuable employee. She's being heavily recruited by other employers. She has a special needs son named Riley, who's 17 years old. She specifically stated she wants to be rewarded for the growth of the company, but does not want stock. Next slide. So let's start with a little bit of a discussion about Maya and Riley and her estate plan. So the first question that comes to mind is exactly what type of needs does Riley have? Under state law, when Riley attains the age of 18, he will be an adult. If he needs someone to make decisions for him, at that point in time, Maya will need to apply for guardianship and possibly also conservatorship. A guardian is responsible for the person, making sure that the person's needs are met. A conservator manages money for the person. So if Riley has any money of his own, he would need a conservator in addition to potentially a guardian. Different states have different requirements for guardianship. Some states allow a limited guardianship. So for example, the ward or person who has the guardian may retain certain rights under the law. One good example of that, Riley may need someone to make his medical decisions, but he may be able to vote. He may be able to drive. So we really have to dig down and see what types of special needs does Riley have and what are his long-term prospects to determine whether he needs a full or partial guardianship, and if he has any assets in his own name, a conservatorship. Generally, we try to avoid conservatorship. That is because the courts control the conservatorship. The conservator has to report to the court every year. The court has very specific rules about investing awards money. And generally, we try to get around that using special needs trust or other types of planning opportunities. Another question that we're going to have about Riley is he going to require needs-based benefits like SSI or Medicaid? Now, Medicare is not a needs-based benefit. Neither is Social Security disability. Here we're talking about benefits for people who are impoverished as it's defined by the law. And it can be defined a number of different ways. Medicaid specifically is a quasi-state federal program. So frequently the state law will dictate the extent to which a person can have assets and still qualify for Medicaid. Also, under all state laws, certain assets are exempt. Just to give an example, frequently prepaid burial plans are exempt. So even if Riley had a prepaid burial plan, that would not be counted as an asset for determining if he qualified for Medicaid. So let's talk a little bit about special needs or supplemental needs trusts. And here specifically, we're going to start talking about what's referred to as a third-party special needs trust. This would be a trust that Maya would establish for Riley. The purpose of setting up the special needs trust is so that if Riley is getting needs-based benefits, he will not be disqualified from aid. The supplemental needs trust or special needs trust pays for things that Medicaid will not pay for. So for example, assume that Riley's needs were so great that he would need to live in an institution or in a group home. Typically, Medicaid will pay for the basic room and board, but what if Riley wants a private room? Then the special needs trust would typically be able to kick in to make sure that Riley had a private room. Frequently, we are putting the special needs trust provisions within a client's revocable living trust. Sometimes, however, we set up a standalone special needs trust. We use the standalone special needs trust most frequently, where the client has a taxable estate and we want to move some cash out of their estate. We can set up an irrevocable standalone supplemental needs trust for Riley's benefit. Or if there's going to be more than one grantor, maybe grandparents are also going to leave some money to Riley, we frequently will set up a standalone supplemental needs trust. Life insurance is an asset that's frequently used to fund the supplemental needs trust. Retirement plan assets are a big question. As many of you know, under the Secure Act created a special class of beneficiaries who are still allowed to stretch distributions over their life expectancy. Disabled individuals are included in that category of eligible designated beneficiaries. So there may be additional opportunities to stretch retirement plan assets. However, we want to avoid having conduit trust provisions in any special needs trust. Conduit trust provisions say that as retirement plan assets come into a trust, the trustee is immediately obligated to transfer those retirement plan assets to the beneficiaries. Obviously, when we're in a situation with a beneficiary with needs-based benefits, transferring those retirement plan benefits to the beneficiary could result in a loss of needs-based benefits. So it's very important that those conduit trust provisions not be included in a supplemental needs trust. Instead, we're typically going to draft that trust as what's referred to as accumulation trust, which would allow the trustee to accumulate the benefits inside the trust and decide when to pay them out for Riley's special needs. Next slide. So now we're going to talk a little bit about executive benefits. And I can tell you, right now, this is really where the rubber is meeting the road. So many of you know that executive benefits are designed to recruit, retain, reward employees. I have a desk full of plans that I'm in the middle of right now because companies are desperate to retain their top executives. That is exacerbated in the case of a non-family, in the case of a family business with non-family key employees. Frequently, the family is not going to give the employee stock, even if they want stock. Here, Maya specifically said she didn't want stock. So what are we using in these cases to tie those non-family member key employees to the business? First, employment agreements. Employment agreements are for a term of years. They typically also contain provisions such as non-compete provisions, that if the key employee leaves the company, they can't go and work for a competitor, generally in the same geographic area. They may also contain non-solicitation provisions that say that the key employee cannot go out and solicit the employer's customers or employees. They may also contain trade secret provisions, confidential information provisions. So employment agreements are a great tool to tie those non-family key employees to the business. But what else do we have at our disposal in terms of retention and reward? Well, we could give the employee equity through a restricted stock plan or stock options. Restricted stock, basically, the company is transferring stock to the employee, and the stock has certain restrictions on it. Typically, it's time-based restrictions, or sometimes it's financial restrictions, and the stock doesn't really belong to the employee until that restriction is met, at which time the stock vests in the employee. So just by way of example, we could give Maya restricted stock and say that if Maya is continuously employed by the company until the 5th anniversary of the stock grant, then the stock will vest. Typically with restricted stock, the employee is taxed at the time that the stock vests. So in the example I just gave, it would be 5 years from now. But the employee can choose within 30 days of receiving a grant of restricted stock to include the fair market value of that stock in their income in the year of the grant. That way, when the stock eventually vests, there's no tax. So they're paying the tax up front. Stock options are a different animal because here the executive is expected to purchase stock at a particular price, the strike price, typically on or after certain events occur. So again, we could have a stock option that vests on the 5th anniversary, and after the 5th anniversary, Maya could buy stock for whatever the strike price in the option award agreement. The strike price cannot be less than the fair market value of the stock on the date of the grant. I'm seeing a lot more activity in the stock option area. There are 2 types of stock options: incentive stock options, which can only be for C corporations, but they have great tax benefits, and non-qualified stock options, which can be for any type of entity. So it could be a C corporation, an S corporation, an LLC. Then, of course, we reach synthetic equity. And I want to talk about 2 types of synthetic equity in some detail: phantom stock and stock appreciation rights. Now, why am I moving on to synthetic equities right here? It's because Maya said she doesn't want stock. So under those equity plans, she would end up with stock. With synthetic equity, she's going to end up with a benefit that's calculated based on what happens with the fair market value of the stock, but she's not receiving actual stock. So let's move on to the next slide. So first, we're going to talk about phantom stock or phantom equity, which is the right to receive cash at a specified date in the future based upon the performance of company equity over a specified period of time. The structure can take a number of forms, and most frequently, these provide a vesting schedule. Next slide. A phantom stock plan is a deferred compensation plan, which is subject to the provisions of Section 409A. 409A was added to the code in 2004, followed in 2005 by about 200 pages of Treasury regulations. If a plan fails to meet the requirements of 409A, either in the way that it's drafted or in the way that it's administered, there are serious tax consequences. One, all vested benefits become immediately taxable. And the taxable amount is also subject to a 20% penalty and interest charges. For whatever reason, my office has seen in the last 6-8 weeks, 4 plans that have been drafted that needed to meet the requirements of 409A that either definitely do not or it's questionable. I don't know why these plans should not be hobby lawyered. They need to be drafted by people who understand the requirements of 409A, not only what's on the page, but also in action. So let's move on. Under 409A, a deferred compensation plan can only pay out at particular times. So separation from service, that could be a voluntary separation or it could be an involuntary separation, like a workforce reduction. We generally, when we draft these plans, say that if somebody is fired for cause, and cause is defined by the agreement, they forfeit their benefit. It pays out, it can pay out at death. It can pay out at disability. Now, disability here is disability as defined by 409A. It's very specific. Change of control of the company also is defined by 409A, very specific. Unforeseeable emergency. I personally, our client base is closely held business owners. I never personally have drafted unforeseeable emergency into a plan. Most of my clients want to avoid administrative complication, and that certainly adds to administrative complication, but it is a payout event that's permissible under 409A. Also at a specified time or pursuant to a fixed schedule. So the plan could say that once the company has EBITDA of $20 million, the plan will pay out to the executive $100,000 a year for 10 years. So that's pursuant to a fixed schedule. Next slide. So let's talk about how the executive is taxed with a phantom stock or phantom equity plan. The executive is normally taxed at ordinary income rates, and the company gets a deduction when the benefit is paid. So in this example, Anna receives 1,000 shares of phantom stock, which will pay a benefit only upon change of control of the company. Remember, change of control as defined in 409A. Next slide, please. Excuse me for just a minute. Where do we use these? Well, we use these plans a lot where owners don't want to dilute their ownership. So a family business is a great example of that. They want all the stock to stay in the family. We also use these plans a lot where the owners want to pay a benefit only upon specified events. The most common one is change of control. So I have a client I'm working with right now. He purchased a company. He plans to grow the company and sell it in 5 to 7 years. He's a serial entrepreneur. He asked me to put a plan in place. It's a phantom equity plan. It only pays a benefit if that executive is there when there's a change of control of the company. And then it only pays out 18 months after the change of control because my client assumes that the buyer will want to keep the executive team in place. These plans, as I mentioned, recruit, retain, reward. Right now, I would say the biggest use is retention. These plans are used where the client wants to link the amount of benefit the executive gets to company value. And I tell clients, the phantom equity plans I draft are full value plans, meaning that if the value of the company goes up, so does the executive's benefit. But if the value of the company goes down, the executive would still benefit because they're getting a benefit that's calculated based on stock's fair market value. These also can be used in various types of entities. So C corporations, S corporations, LLCs. Next slide. So what clients like about these plans is they don't dilute the existing ownership group. They don't have an effect on cash flow typically. depending upon what the payout events are. Change of control, actually, you know, when we have a change of control, of course, there's enough cash there to pay the benefit. So that doesn't become a problem. The client can define when the plan pays out. There's tax deferral for the executive. They're not going to get taxed until they actually receive a benefit. And as I mentioned, it's available to many different types of entities. Now, on the challenges side, the company's deduction is deferred until the employee receives their benefit. The employee is taxed. The employees don't have any voting rights or dividend rights. This is not actual equity, it's phantom. It may not be meaningful to the executive unless it's described the right way. You know, these executives who get phantom stock, let's say it pays out at a change of control, I mean, that could be the biggest one-time payout event they ever get, and they need to understand the benefits. And of course, it is a deferred compensation plan subject to 409A. Next. So now let's talk about equity appreciation rights. So as I mentioned, my phantom stock plans are full value plans. Appreciation rights, the executive only gets a benefit if the value of the company equity goes up. So here, it's the right to receive cash on or after a specified date in the future based upon the difference in value of X units of equity on the grant date and the value of the same number of units on the exercise date. So here, Rob receives a grant of appreciation rights in 100 shares when the stock is worth $5 a share. At exercise, the stock's worth $10 a share. What Rob gets is $5 a share, the difference between the price on the exercise date and the price on the grant date. Next slide. Now, again, the participant is taxed at ordinary income rates because this is compensation, and it's generally taxed at the time that the benefit is paid. So here, Rob exercised his appreciation rights in 2018. He included $5,000 in his income. That's $5 a share in appreciation times 1,000 shares. And he was taxed at ordinary income rates. So where do we use these? Again, where owners don't want to be diluted, where they want to recruit, retain, and reward, and where they want to tie the incentive to the executive on the success of the company on a go-forward basis. Because remember, what the executive is getting is the upside. If the value of the company stays flat or goes down, the executive gets nothing. And we have lots of flexibility here, again, to add conditions to exercise. We frequently have a vesting schedule. Maybe it'll be time vesting. Maybe it will be vesting upon achieving certain financial goals, or sometimes we have both. Next slide. So we like these because they're not dilutive. The company has to be successful for the executive to get anything. They're very flexible, simple to understand. No problems with the companies administering these, and there's no tax until exercise. Again, on the con side, the executive doesn't have the rights of a stockholder, but just Maya's example, she doesn't want the rights of a stockholder. She doesn't want stock, but she may appreciate appreciation rights. Next slide. So let's talk a little bit about split dollar. I mentioned split dollar a couple of times in this presentation. First, when the Feldman children are potentially thinking about buying out Jack and Diane, their parents, they may want to use a split dollar life insurance solution in order to fund the purchase of life insurance. Also, this may be of interest to Maya, because Maya is considering setting up a special needs trust for Riley. Life insurance is a great tool to fund those supplemental needs trusts. And split dollar is a very economical way to fund the purchase of that life insurance. So split dollar can be most easily defined as an arrangement where a business and a key employee or owner share the costs and benefits of a life insurance policy. And there are two general flavors: endorsement split dollar plan, which are taxed under the old economic benefit rules. So basically, the company pays the premium. The employee includes a portion of the premium equal to the term cost of the coverage that they are acquiring in their income each year. If you've been around a while, you may remember back before 2001, we used something called the PS58 cost to determine what the employee would be taxed on. Now, however, we use the Table 2001 rates, or if lower, the carrier's one-year term rates. So endorsement split dollar has been around a long time, still essentially taxed the same way. Collateral assignment split dollar has been around a long time too. Generally, after 2001, collateral assignment split dollar is taxed under the loan regime, and we're going to get into that in just a minute. There is an exception for non-equity collateral assignment split dollar arrangements, which basically can be more similar to the taxation of endorsement split dollar back to the economic benefit rules. Next slide. So we're seeing a big resurgence of interest in endorsement split dollar at my firm. With endorsement split dollar, the company owns the policy. The company typically pays the premium. The executive is taxed on the economic benefit, which is the term cost of their interest in the policy. The executive is given the opportunity to endorse the death benefit over and above the company's interest to the beneficiary of the executive's choice. The company retains the right to get the greater of premiums or cash surrender value of the policy back if the executive dies. The balance of the policy proceeds then are paid to the executive's beneficiary. Let's talk now about collateral assignment split dollar. Next slide, please. So with collateral assignment split dollar, someone other than the company owns the policy and collaterally assigns an interest to the business equal to the greater of the loan balance. We're going to talk about that in a second. Is assigned back to the company, and the balance of the proceeds passes to the owner, who is typically the beneficiary. So let's talk about these loans. So the loan, every premium payment that the business makes is considered a loan to the policy owner, the insured. Those loans accrue interest at the applicable federal rate. If it's a demand loan, it uses the blended rate, the blended AFR. If it is a term loan, it uses the appropriate AFR rate, which is published by the Internal Revenue Service every month. If the employee dies, as I mentioned, the loans are repaid. The loans plus interest at AFR are repaid to the company, and the owner keeps the remainder of the proceeds. Now, where might this be a good fit? What about Maya? Maya could set up a standalone supplemental needs trust for Riley, an irrevocable trust, an ILIT with special needs trust provisions in it. The interest in the policy, it could be endorsement or collateral assignment split dollar. It could be collaterally assigned back to the company. During the term of Maya's employment, the company could continue making those loans so that she could pay the premiums. Next slide, please. So collateral assignment, employer loans premium payments to the employee to pay the policy premium. Loan is repaid when the employee separates from service or dies. We'll get to that in a minute. Loans can be demand loans, payable on demand, or term loans for a term of years. And I mentioned the appropriate interest rates that you see up there on your screen. Next slide. So let's talk about termination of employment, because this comes up a lot. What happens at termination of employment? Well, one option is the employee could pay back the loan, the split dollar agreement terminates, and the employee keeps the policy. Another option, the employer could forgive the loan. In that case, the employee is taxed on the amount of loan forgiveness. So that is loans to pay the premiums plus any accrued interest. Or if the employee dies during the term of the arrangement, the reimbursement to the employer comes out of the policy proceeds. Next slide. So why do we like this? And I really do like this option for Maya. I think collateral assignment split dollar could be a good option for her to fund a special needs trust for Riley, because it would allow her to purchase a lot of life insurance at a minimal out-of-pocket cost. Now, if we put the policy in the ILET, she couldn't use it for supplemental retirement income, but in other cases, we can structure split dollar so potentially there would be supplemental retirement income for the insured, and I'll get to that in a minute. It's a selective benefit. So for example, the company could offer this benefit to Maya and wouldn't have to offer it to anybody else. There are very few ERISA requirements and very little administration. Now with endorsement split dollar, the economic benefit may become prohibitively expensive at older ages. For whatever reason, clients always think that life insurance premiums should be deductible. They're not, they never are. There's a perception that split dollar taxation rules are complicated. I think that perception about the complication came from all the changes that occurred so quickly at the beginning of the 2000s. But really, the split dollar rules are not complicated, and they can be navigated by the right advisor. Next slide. So, my second polling question, which of the following gives the executive benefits on a go-forward basis only? Is it phantom stock, stock appreciation rights, both of the above, or neither of the above? I feel like I'm on Who Wants to Be a Millionaire reading these questions. All right, and for the 30% of you that said stock appreciation rights, you're the winners. All right, moving on. I got to bring it in. We're in the home stretch here. So what about the remainder of the executive team? Maya is obviously of special interest because she's being so heavily recruited and because she's the best employee. What about the rest of the executive team? Well, moving on. We have an executive team who is 37, 48, and 61. Those are their ages. Is there a plan that will appeal to all of these executives and future recruits? Well, how about a SERP? A SERP is a supplemental executive retirement plan. It's a 100% employer-paid, non-qualified plan that provides benefits to a select group of employees. And it's defined as a select group of management or highly compensated personnel. That's referred to as a top hat group. Under DOL rules, if a plan is just for the top hat group, it is exempt from most ERISA requirements. It can either be established as a defined benefit plan or as a defined contribution plan. It's subject to 409A. So all those rules that we talked about before with regard to 409A still apply in the case of a SERP. Next slide. Next slide. There we go. So which plans of all the plan designs that I've talked about today can be informally financed with life insurance? Well, first, we should talk about why use life insurance to informally finance. It's all the reasons why life insurance is a great tool in all different types of planning, whether it's succession planning, estate planning, or executive benefits planning. It's the tax-deferred cash accumulation. It's the tax-free access to the cash value through withdrawals and loans. If the employee dies, the company can receive tax-free death benefits if all of the requirements of Section 101J, notice and consent requirements, are complied with. And the company can even keep the policy for cost recovery for putting the plan in place. In some cases, there are high early policy charges. And of course, we have a 61-year-old here. It would be difficult to use policy values for older participants because that 61-year-old is going to need a benefit a lot sooner than a 37-year-old. But we don't have to go one-on-one, one policy per participant. We can do more of a group funding. And of course, our client's least favorite thing, premium payments are not deductible. Next slide. So I talked about split dollar and I talked about SERPs. And now here's our bonus planning idea, which is SERP dollar. It's two benefits in one. So think about this maybe for Maya. So we put a split dollar plan in place, which provides a pre-retirement death benefit for Maya's beneficiary that would be received income tax free. But the cash values of that same policy, which is owned by the business in this case, so we're talking about endorsement split dollar and a SERP, the cash value of that same policy when Maya retires can be used to informally finance her benefits under the SERP. So it can provide a stream of supplemental retirement benefits for Maya. Next slide. So, which executive benefit plans may be informally financed using life insurance? Is it phantom stock? Is it appreciation rights? Is it SERPs? Is it all of the above or none of the above?
Kathleen, this is Rob. As they are answering, we've got maybe 3 or 4 minutes, and then I do have a couple questions in the queue that I'd like to get to, please.
Okay, that's okay. Getting to the end of my long-winded presentation, so let's see what they say.
Thank you.
All right, and for the 22% of you that said all of the above, you are exactly correct. So most planners think about using life insurance to informally finance a SERP. Most planners do not think about life insurance to informally finance phantom stock plans or appreciation rights plans. Now, if you have a plan that only pays a benefit on change of control, the life insurance informal financing won't be needed. But if it's the death of the executive that's a payout event, life insurance can be great to informally finance phantom stock or appreciation rights plans. Next slide. Okay, which brings us to Doris. This always happens. Doris has been with the company for a long time. The parents want to reward her. So they tell me, put her in the Top Hat plan. And I say, can she be a member of the Top Hat group? Is she a member of a select group of management or highly compensated personnel? No. Are there other options that might work better for her? How about cash? What about a cash bonus plan? It may be that there are other things that we need to look at and stay away from the fancier stuff and just go with cash bonus. Next slide. Okay, Rob, we can open it up for questions now.
Thank you. Before the first question, let me react just for a moment. So many of your remarks and comments, the technical aspects, I've got notes and I'm saying, and that's fantastic. One of your remarks made me smile a lot, and that was the term hobby lawyer. So I hadn't heard that before, and I don't know if that's the separate LinkedIn group as well, but let me get to the...
Hobby lawyering is not a good thing. It's like the internet, Rob. Clients come to me and they say, I found this on the internet. And I say, you know what? The internet is not a very good lawyer. Hobby lawyers are also, my dad was a doctor, and when he retired, he decided that he was going to devote much of his time to hobby lawyering. So he wrote lots of complaint letters and things like that.
Oh,
but
God.
Hobby lawyering in this case is not a good thing.
Not a good thing. Okay.
Not a good thing.
I have a question under the topic of split dollar. And the question specifically, in a situation with a C corporation, which type of split dollar perhaps would serve the owner the best?
From the owner's perspective, I would still probably say collateral assignment split dollar.
Okay. Can you say why?
Well, because you can get the entire death benefit out of the owner's estate, if that's going to be important, by setting up an ILET. The drawback, I think, well, there are a couple things, but endorsement split dollar, I think, was less popular among the executive team when the exemption was lower, because the amount that you have the right to endorse is includable in your gross estate. With the current estate tax exemption of $11.56 million, and the fact that even though it goes down in 2026, it's going to be index $5 million index for inflation, which is $6.1 million per person. A lot of executives now don't have an issue if we've got $1 million policy that's going to be brought back into their estate because they had the right to endorse. But I still think collateral assignment works well in that scenario.
Okay. Thank you for that. Could you speak either generally or specifically to the need or importance of collaboration, specifically with the financial advisor?
Oh, that's a huge one. Everybody says, I like to be the quarterback. I don't have to be the quarterback, but I do have to be part of the team, and the financial advisor has to be part of the team. And the reality is, when we all work together, we get a better solution. And that includes the client's financial advisor, the attorney, the CPA. Everybody really needs to be on the same page. And I try and set something up with a call with the financial advisor, a call with the CPA, so that the ideas that are going to be presented are vetted by everybody prior to the meeting. Because you don't want to be sitting in front of the client and having the advisor group disagree. That's bad.
Thank you for that. I do want to mention, and then I'll hand it back to Brock to be respectful of time. I want to mention that following the part 3 next week, then we'll make the slides and the recorded video presentation available to the participants. So that was a question that had come in.
So here we go. Tune in next week when Andrew Wren of Emeritus is going to dig deeper on a few great planning ideas that will work for generation 3 of the Feldmans. For example, creating estate equalization, solving the Maria dilemma, and crafting a business transfer to Hunter. Don't miss it.
Kathleen, thank you again. That was fantastic. I'll hand it back to you, Brock.
Awesome. Rob, Kathleen, thank you very much. It's awesome. It's good to know your blind spots. And I think this really highlights for me. I mean, like Rob, I wrote down hobby lawyering. I also wrote down notes, and I just put this one note. I said, I'm sure glad there are attorneys like Kathleen who can help read and decipher all the details of things like 409A and 2703. I mean, I like to nerd out on some of this stuff, but this gets pretty deep. So thank you. Really good stuff. Love that sort of juxtaposition of all the different facets of the legal, the tax, the investments, the insurance, and how it all comes together. And I think it's part of being a good team, whether you're the quarterback or I saw a good analogy the other day that said, sometimes it's good to have some great offensive linemen, right? And offensive linemen don't always get all the glory, but they do the important work. And so really good stuff. I also loved, I grew up in Indiana, so I love the Jack and Diane reference, good John Mellencamp story there. But I think I'd tell everybody, same time, same place next week. I'm looking forward to hearing about how we resolve the Maria dilemma. That sounds fascinating. But really thank everybody. Thank you for being here. Thank you for your great questions. If there was anything that didn't get answered, please feel free to to let us know via email, and we'll try to get everything answered next week. But otherwise, my clock says 3:01, so we're over time. But Kathleen, really appreciate it. Look forward to Andrew next week. And Rob, thanks for sort of co-hosting with me on this. So appreciate everybody, and have an awesome remainder of your day.
Thank you.